Welcome everybody. I know it's a challenging first session after lunch, so hopefully everyone's caffeined up and awake for this one. We'll be discussing the M&A challenges and trends in 2015 in India and going forward. What we hope to cover in this session is touch upon the current deal-making environment in India, the challenges being faced, and also try to identify certain trends in the making. We will set aside around 10 minutes or so towards the end of the discussion for any Q&A. But if you have any urge to ask questions midstream, please raise your hand and I'll try to accommodate that as well. I will be moderating this panel. My name is Siddharth Bhasin. I'm a partner in the M&A group at Sherman & Sterling. I started off in New York, spent about 6 years there before moving to Hong Kong, spent 8 years in Hong Kong, and 2 months ago moved to Singapore. I also lead our India coverage for the firm. And been doing a lot of inbound and outbound M&A and private equity work in India for many years now. Let me also introduce my panelists here. Bharat Vasani, he has more than 30 years of in-house experience. He has been the general counsel of the Tata Group since December 2000, and he also sits on the board of various Tata Group companies. He has extensive experience in corporate matters, joint ventures, international, large, complex M&A transactions, and high-profile litigations. He's regularly consulted on public policy and corporate issues. He has advised the Government of India on several matters, including the Companies Bill and the Competition Act. He has also participated in several training programs at Harvard Law School and Harvard Business School, and won several awards, including the IFLR Award for Outstanding Achievements and the Legal Era Award for the Best General Counsel of the Year. I've personally known and worked with Bharat since more than 10 years now. When I was a very junior, young associate in New York, I had lots more hair in my head and less in my face back then. It's great to have you on the panel, Bharat. Then we have Samir Chugh, who is the Director, Legal and Regulatory for Bharti Airtel. He read law at Symbiosis Law College, Pune, also did his master's in marketing management from there. He holds an MSc in telecom business from University College London. Samir was in private practice before going in-house, and has previously worked with NCR, BT, SR, and Cummins in various roles doing corporate M&A and litigation work. And he has worked in more than $12 billion worth of transactions in his career. Welcome, Samir. And last, but by no means the least, is Ashwath. Ashwath Rao is a partner at Amarchand Mangaldas and deputy head of its general corporate practice in Mumbai. He handles complex cross-border work across M&A, private equity, and funds. He's consistently ranked by Chambers Legal 500 and Who's Who Legal as a leading practitioner in India. He's the member of the IBA Investment Funds Committee. Most recently advised on Kotak's merger with ING. And his key clients include Holcim, Tata, Kotak, SBI, JP Morgan, Bain Capital, Fidelity, IDFC, BNP Paribas, and the Times of India Group. Welcome, Ashwath. So welcome to all the panelists. Thank you for being on this panel. So I thought we'd begin by just understanding a little bit about the current lay of the land and what the deal-making environment in India has been. There clearly seems to be a renewed appetite in India for M&A transactions. When the new government came into power, there was a lot of fanfare and euphoria, but it also came with a bit of a risk on whether the government would be able to live up to its expectations and deliver on the very high standards that were expected of it. It's been a little over a year, and while there are issues that still need to be addressed, it does seem like deal-making on the whole is back in business. I have some statistics here that I wanted to share with you on M&A in India in 2014. I got these from Merger Market. 2014 was clearly a very strong year for M&A compared to at least 2013. There were approximately 300 deals that were announced, totaling $32 billion in value. This was an increase of 43% by deal value from 2013. And the average deal size also increased by 31% compared to 2013. However, the interesting thing to note here is that a lot of the activity has been either domestic or inbound. In fact, the outbound activity dropped 79% compared to the years prior to that. So let me just sort of throw this out. So given these statistics, is the sense now that corporate India has effectively written off outbound acquisitions. I know, Bharat, you've done a lot of acquisitions with the Tata Group, large, complex outbound deals. Do you think that corporate India is now no longer looking at being as global as, say, years 2006 and 2007?
Well, good afternoon, first of all. I think it would be improper to say that we have completely switched off when it comes to outbound investment. In fact, not the case. But yes, we have become more selective. The frenzy of 2006, 2007, 2008 till the Lehman Brothers happened is certainly not there. The number of deals are fewer. The sizes of the deals have come down very drastically. But we are all the time looking at attractive targets, and if you get a good asset at the right price, still the deals are happening. It's not that they are not happening, but they are fewer and far between. So let me put it this way. There's a more focus towards inbound than outbound.
Right. Yeah, so it looks like it's being more opportunistic rather than just expanding for growth's sake. Yeah. Sorry, Ashwat, you had something to add?
No, I echo that. We are seeing, for example, IT still is active outbound, logistics is still active outbound, IPR-driven strategies in terms of actually acquiring technology-based companies offshore is still something that we are seeing on the ground. But having said that, I think the fundamental difference between a few years ago and now probably stems around the fact that a lot of Indian corporates, believe that there is an opportunity today to, probably correct the problems they have at home in terms of, in many cases, projects that have been stuck for a very long time. Investment opportunities are at some level believed, I don't know whether they have, but there's a belief that investment opportunities have now opened up domestically. So I see a more domestic focus amongst the larger corporates that we work with, where I think the sense generally is that there is opportunity now to be, had here. So I think the outbound look, which was, I think, also driven partially by the situation in India, 3 to 4 years ago or over the last 3 years, I think has changed. That's been a contributor, I feel, to the general change in approach.
Right. Got it. So I think on that note, let's sort of look more inwards and see what's been happening on the inbound and domestic front. It clearly looks like that's where most of the action is right now. So I thought we'd sort of dive a little deeper and talk about some of the challenges that acquirers are facing, both domestic as well as international acquirers, in doing deals into India. One of the big categories of issues that people have faced in India has been around legal certainty. In most of the deals that I've done, at least in the cross-border side, the first issue that invariably comes up when you're looking at an inbound transaction into India is tax. It's tax and the certainty of tax treaties. There are really two issues here. So one of them is indirect transfers and how that sort of gets impacted from a tax perspective. And the second is the certainty of legal treaties from sort of how the whole general avoidance rules will play into the tax treaties that India has with several jurisdictions. So perhaps we start with the indirect transfers first. The recent budget tried to address some of the issues that were raised by the Vodafone case and indirect transfers in general. But there are still a few gaps that still need to be filled, and like they say, the devil lies in the details here. But I would love to get your thoughts on how you think these issues are impacting exits in particular, and consequently, obviously, new investments coming in as well, and whether you think the budget has done enough or there's more to be done. Samir, do you want to?
Yeah, so I think before really getting into the big, kind of the nitty-gritties, what's also important is to really understand what the investor or what the people who are looking at the M&A transactions are thinking about. Because the one thing that definitely we lack here is clarity at this stage. While with the change in the government, a lot of things happened in the sense that you at least saw a full majority government saying things will be stable. But do we still have the clarity around, the various, I would say, laws? In fact, I wanted to actually say this, that yesterday we heard Mr. Ravi Shankar Prasad speak here. He started the session. And he talked about good governance and trust and clarity. And although, he made statements, and I think he's got the right intentions, and so probably does the government. But the fact that there is still a lack of clarity, whether it is in the laws, whether it is then in the compliance, whether it is in a position where you require to make several filings, and the way that you are getting dealt with, I think that is something that is going to play a big role on how much of M&A will get driven, here. To the extent that while there may be local companies or Indian business houses will probably still continue to turn around and invest and acquire, because they probably know the rules by now, they know how the game is played. But look at it from the perspective of a foreigner who is coming into India and has no clarity. I mean, going back to then the nitty-gritties of what you said, from a clear tax perspective, I mean, how many years has it taken us to turn around and provide the clarity on the Vodafone bit?
Correct.
So I think that some of those issues will need to be addressed very quickly for the M&A to really take off in the sphere or in the manner that we would ideally like it to be. But till that happens, it is still going to be a much slower, path that I see.
Right. Now, I think you've identified a good point, or you make a good point. It's not the fact that we are trying, or the government, I should say, is trying to tax certain transactions. It's the manner in which they went about doing so. And from a foreign investor's perspective, it creates a lot of uncertainty. And that's exactly what you want to avoid. To cultivate a more favorable environment for deal making, you need certainty of laws, and retrospective changes, retroactive changes are just definitely not the step in the right direction. Ashwa, are you seeing an impact on deal structuring, exits, given the ambiguity with indirect transfers?
Let me just start to that with Vodafone, because
Sure.
Vodafone as a case, I think, is probably the single largest impactor on foreign investments in our country, maybe even in a 10-year horizon. Because I remember at that point of time, the finance minister, the current president, famously said, even if an investor comes and tells me that he's going to put $200 billion into the country, but doesn't want to pay capital gains tax, I don't want that investor. And that sort of thinking drove, what they did going after Vodafone. And I think what really cleared the pitch overseas was not the case. It was the government retroactively modifying the law after the Supreme Court said that the transaction was not taxable. But, I mean, I still think that is a little dated now. At one point of time, I remember fund managers in India who were looking to raise capital from overseas for investment here basically said that they weren't allowed to finish their tea or coffee after they said they were looking to raise an India-specific fund. Now, the sense I get from that very same crowd is they're getting invited to lunch and dinner, but money has not necessarily started flowing. And let's look at, I think, progress from where we were on Vodafone. I think one of the criticisms of the current government after 2 budgets is they haven't tackled Vodafone, in the sense that they haven't undone some of the retrospective damage that was done. But, as lawyers here, I think all of us understand the fact that it's not that easy to undo, things that have already been done. There are inherent challenges constitutionally. The matter, as we all know, is back in the courts again. So I think the current government's position is let it go through the judicial system now. Whilst one may not necessarily agree with it, one has to concede that that is one point of view. But if you look at what they did in the recent budget on indirect transfer tax, I think there have been a whole slew of useful things that they've done. A lot of the Shom Committee recommendations in terms of actually giving, foreigners comfort around the fact that their global transactions are not going to be taxed simply because they happen to have been invested in India. They've defined what's substantial in terms of substantial assets in India. So I think on indirect transfer, that's actually positive. As far as GAR is concerned, and GAR was a big fear in terms of Mauritius being closed down, I think that's positive from an overall FPI/FII fund flow into the market. But if you look at it in the context of, say, private equity or strategic investment, I don't think the postponement by 2 years and the assurance that it's not going to be, applied retrospectively is really going to help outside of the public listed market. It is certainly not going to help private equity and strategic acquisitions. And what we are seeing now increasingly is that a lot of investors from overseas are coming in directly from their home jurisdiction without stopping, at a treaty jurisdiction to bring the investment through there. And clearly we are seeing a move away from Mauritius to Singapore. So whether it's the fund industry, private equity investors, or even strategics, There's an Asia hub concept that is, starting. A lot of Indian institutions have also actually set up presences in Singapore. So clearly, there are changes that we are seeing which are meant to achieve a positive result. I don't think anything is going to change overnight, but directionally, I mean, at least I, as a practitioner, I'm a lot more comforted from where I was, say, 1.5 years ago.
Right. But I mean, you make an interesting point, especially with this GAR coming in or expected to come in a couple of years. Singapore has definitely become the jurisdiction of choice to invest into India. I guess one reason is because it's easier to create substance in Singapore than others. But GAR, as you know, is obviously applicable universally, and Singapore would also get picked up by it. But are there issues you think that needs to be addressed between now and when GAR is actually implemented that would make it less disruptive to the deal-making environment?
No, I think Singapore, as you mentioned, so that the advantage you have in Singapore as opposed to Mauritius is the ability to create substance. And, I don't think parties really need to try. All you have to really comply with is the MAS norms that they stipulate, and you create substance. So I think Singapore is certainly going to be more secure than Mauritius has ever been. I don't expect, Singapore to become the next Mauritius. But let's also just pause and think about Mauritius for a minute. The fact that Mauritius as a route is going to be closed down 2 years from now is not necessarily good from an economy and an investment into India perspective, because how many clients we all deal with actually have the ability for a, say, $100 million fund or a $150 million fund to actually go and set up a presence in Singapore, because it's expensive to do that. So one outcome of GAR coming into play 2 years from now, I mean, I think Mauritius tapering off is a reality. There are political compulsions clearly around Mauritius. I think we all read the newspapers today where the Prime Minister has basically said we're going to renegotiate that particular treaty. So unfortunately, Mauritius has actually become synonymous with, round tripping and money laundering and all the bad stuff, which is sad. Again, it's like we can discuss in the context of, I'm sure, discussions we're going to have on this panel on how domestic investment is playing out and what the problem is. I think legislating for the exception is the problem. I mean, there's a lot of benefit in keeping Mauritius intact. So I, for one, believe that whilst we should get treaty renegotiations done on information access to figure out where the money is coming from and, making sure that that route is not misused, I think that is certainly something that needs to be done. But killing Mauritius as a treaty jurisdiction coming into India is actually going to cost us a fair bit of capital inflows, which can't afford to come in through Singapore. So
yeah, and I completely agree with you, and which is why at least the hope is that by the time GAR comes into effect, they would have refined it enough so it would not have these inadvertent consequences. But just sort of on this topic about how the Vodafone case and some of the flip-flops that the government has done in some areas of law in India. So tax is one, you've got options, you've got pricing regulations. How is that, and I know you interact a lot with foreign parties, how has that affected the view of India for foreigners?
Yeah, if I can be candid, when Vodafone happened, I think next week I was in London, and the kind of debate quite shocked me. In fact, that was a very, very rude shock, that a Supreme Court judgment is being overruled through a retrospective amendment going back for 40 years behind. And in fact, questions were asked, do you have a rule of law in this country? Mm. From that, I find we have traveled quite a distance now. I can see directionally we are going in the right direction. I don't know whether you've seen the finance minister's budget speech this year, which was delivered 10 days ago. At least there are 7 major legislative policy-related changes which are announced, which are nothing to do with the budget, like setting up commercial division of the High Court's bill. The bill is going to be introduced in the current session of Parliament. The new Arbitration Act, which is coming. There is also new Public Contracts Dispute Resolution Bill. So there are a whole host of measures which have been announced, which will certainly be much more attractive to foreign investors. Apart from the fact that now whatever flip-flops happened in the previous regime in the put and call options, when December 2013, they said that put and call options are bad unless their returns are on the basis of ROE, no assured returns. Everything was turned upside down. Then again, from July 15, the policy changed that any internationally accepted method, pricing guidelines change. So I think directionally, but what happened is that last 6 months of the previous regime, so much of damage was done in terms of new land acquisition bill, the other issues which were passed through in a very tearing hurry, that this government is finding it time to correct those mistakes. And problem is, with yesterday we saw how the insurance bill got passed, but we required a Congress party support to get it passed. So there are lots of issues. I think lots of reform bills are currently also referred to the select committee or parliamentary standing committee because they don't have the numbers in Rajya Sabha, the upper house. As far as flip-flops are concerned, I think India is known for it, but I think now we should hopefully go for a stable regime. At least Mr. Jaitley has announced on the floor of the parliament there won't be any more retrospective changes in the tax laws. And I take his word, and I go by it. And I don't think in the last two budgets which he has presented, there is a single amendment which can be called retrospective in nature.
Right.
So that's a positive sign. I think the tax rates are more or less becoming stable, except the service tax which has gone up this time. As far as the other changes are concerned, India is a very complex country to manage. It's a very, very different country than many other countries are. See, for example, FDI in retail, it's not only the central government, the state government has to agree because the trading is a concurrently subject. So even if the central government announced the policy on multi-brand retail, only 6 or 7 states which were then at that time Congress rule supported it. So it's a very complex, you can't make the changes overnight. It takes a whole host of measures. And the laws are also not made by one parliament in Delhi. They are made by several regulators sitting different parts. IRDA makes its own regulations, TRAI makes its own regulations, SEBI and RBI make their own regulations. So the fact that we want to make India the easiest place to do business, it should percolate down not only with the central government, but all over the place. And I think it will take some time. For example, the new delisting regulations, it's a case in point. All of us thought that with all the problems we faced with reverse book building, the delisting regulations would make it the life much simpler and the reverse book building will be replaced by a fixed price offer. In fact, the regulations have become even more stringent, except for the fact that they are now allowing tender offer for you to go for delisting. Apart from that, if you see, the delisting has almost become impossible. Now, any multinational investor which comes to the country, the first precondition is in the ownership structure, I don't want any listed company. I would want an unlisted setup because listed company, you have to go through the rigmarole of clause 49 of the listing agreement and all the provisions relating to this corporate governance. Problem is you can't delist the company. Going it private is so difficult in India. So I think all those changes will take some time. Even the insider trading regulations which have been announced about on 15th of January, many things have been done. But if you see, due diligence now will be permitted in a listed company, but conditionality which they have put for due diligence are virtually making it difficult. Similarly, trading plan, the concept of trading plan is introduced in Regulation 5, but if you see the conditions which are attached to the making of the trading plan, making it very difficult.
Right.
So there are so many such regulations, and the New Companies Act, in fact, which has made some of the deal making even a little more complex. So, I was discussing with Ashwath, we were together in the flight together. There was a complete flurry of activity in 2006, 2007, 2000. I said golden period of Indian lawyers, that so many deals happened and merchant bankers. Now we are chasing very few deals, but the time taken, we are all very busy. Because it takes so much longer to consummate the same deals because of the number of complications we have. So consummating the deals and completing it is taking much longer than it used to be in 2006, 2007. Hopefully this period will come down.
Yeah. And I think you've raised a lot of good issues, especially around the regulatory impediments in India in doing transactions here. And we should touch upon a few issues that you raised, but before we go there, Samir, anything to add on just the legal certainty point? How do you see this as being an issue for foreign investors coming in? Has the budget done enough? Do you think we should have done, or the government should have done more than what they've done?
I think, a lot of that has already been talked about. But the one thing that definitely, I can say is, from a government standpoint, they need to ensure the speed as well. I mean, while they are going in the right direction and they are turning around wanting to do the positive movements to ensure business is easier, but again, it has to be done very quickly. And I completely am on board that, the last government did a lot of damage and it takes time to undo what's been done. But I think they need to really start to think about what are the additional clarity that people need immediately. I mean, while on one side we say, for example, the whole thing about, make in India, digital India. If you look at that, what is the need? Do we have that technology in here? Not really. Are we able to get the technology in very quickly? Not really. So you want to do something, but you're not able to do it. And clearly, the current laws, the new regulations that come out, have to be far more investor friendly. Now, I'm not at all saying that we should be turning around and letting it be like open house, come do what you want. Governance is important. And if we can follow the same international standards, I mean, I don't see a harm in shamelessly copying here. I mean, US does it, UK does it, just get some of those stuff here, do it. And look at some of these investors, they will be able to, they'll be very happy to follow it. They don't have a problem. They've been doing it there, they'll do it here also. But what you really need to take away is the bit that once you've got an entity going, thereafter the requirements that you have, you know, the filings that you got to make, then there'll be somebody who'll inspect, they'll inspect at their own sweet time. After taking 6 months, 1 year, 1.5 years, they'll come back and say, oh, you know, there's an error, and then they'll try and slap a fine on you. Now, all of those are things that an investor thinks. I mean, it's not just about coming in, doing a deal, walking away. I mean, you do a deal, that's just probably the start point. You do a deal so that you can run a business. And if you can't run a business, would you really do a deal? Therefore, the impact on M&A to say that how do I really turn around and get into a business which will then turn around and help me grow my global ambition. How do you do that? And that's where the government has to make the ease right from day one, saying if you want to invest, if you want to acquire, the process is easier. I mean, simple things like, can we have a one-window clearance? Rather than going into 5 different places. I mean, you need to go to FIPB, you need to go to Competition Commission. You need to go to, you know, for example, if you look at the telecom side, you need to go to DOT. I mean, 2 entities merging in India takes so much of effort. Yeah. Think about what a foreign investor goes through. Yeah.
Right. No, I agree. So I think so the sense I get is that the government and the regulations have to be enablers to deal making, not really roadblocks, which some of them inadvertently have become. I mean, just to pick on a few examples of where, say, a well-intended change has had unintended consequences is this ownership and control issue. I think the thinking behind the concept was legitimate, but it has resulted in quite a few roadblocks to the deal-making process. And on the ownership side, it's still quite easy to determine relatively on whether you're a foreign-owned company or not. But when you get into the whole determination of what constitutes control, that's where it becomes a lot more ambiguous. I mean, Ashwath, do you have any thoughts on?
And so that I think you brought it up at the right time, because my co-panelists basically, you know, brought in points on lack of certainty,
exactly,
lack of objectivity, lack of regulatory coordination. And I think the issue of control is probably the perfect example of where I think it straddles across all of those. If you look at what happened in Jet Etihad, yeah, the word control, I mean, it's a complex word, but you know, if you look at the views that were taken by the 3 governmental bodies involved in it, which was SEBI, the Competition Commission, and the FIPB, you had different conclusions arising out of each regulator. Now, the simple way of sort of dealing with that would be to, you know, have an objective definition. I think there are SEBI-created panels which have looked at control and said, look, it's not possible inherently to create an objective definition around control. But that having been said, you did have an opportunity, and you know, you did have an opportunity when the Shubhkam case got decided by SEBI, where SEBI said, look, a private equity investor having a bunch of veto rights effectively has control. Even if it's negative control, it is control. And then it went to the SEBI Appellate Tribunal, and in a very interesting analogy, the SEBI Appellate Tribunal said, look, take a car, somebody's driving the car. Now, who's got control of the car? The guy who's got control over the clutch and the accelerator, or the guy who's got his leg on the brake? And they said, look, the guy who's got control over the brake doesn't have control over the car. It's the guy who's got the accelerator who decides at what speed it moves. So the SEBI Appellate Tribunal came to the conclusion that, look, a set of veto rights is not control. Now, the matter went up to the Supreme Court, and SEBI did a deal where they let off the appellant in that particular case, and they got the then Chief Justice to basically pass an order saying that, look, the SEBI Appellate Tribunal decision has no precedent value. So, you know, this is a classic example of an issue which is found in, you know, you have control definitions under the Companies Act, the Competition Act, FDI policy, FEMA, you know, it's all over. And this was an opportunity for the Apex Court to actually settle a question of law, and it let that chance go by. And even a inferior appellate authority's decision was discarded as not having precedent value. Now, there are valid points of view, but then if you look at what Etihad went through in their transaction with Jet, it was a complete circus. And I guess the basic point here is, as an Indian practitioner who deals with, clients from multiple jurisdictions, the problem we face really is the sheer amount of gray we have in our country. I mean, if a client asks you a question on, can I do this or not, how often are you as a attorney, whether you're in-house or, an external lawyer, able to say yes or no? I mean, most of the time it's maybe, right? And then after that, your entire job is to try and structure your transaction to bring it towards the whiter shade of gray rather than the blacker shade of gray. And it's ultimately, we hooping. I think all of us probably, make our reputations by probably getting our clients to, the whiter shade of gray rather than the darker shade of gray. But firstly, it's becoming very difficult to predict which is what anymore. And frankly, investment is completely premised on certainty. And the absence of certainty is, I think, what is really hurting cross-border or even local investment. Today, you do a completely domestic transaction. We are talking about income tax. I mean, the kind of problems that we've had on stamp duty, we are in Delhi, coincidentally, and the collector of stamps in Delhi has gone berserk in, the last 1.5 years. And the sheer number of orders that he has passed and have been stayed by the Delhi High Court has in between created heart attacks all over the globe, because the numbers you're talking about are, 300, 400, 500 crores of stamp duty being levied in situations where there's absolutely no case for levy. So, I think aggressive revenue authorities is one problem, but I think the bigger problem is the lack of certainty.
Yeah, no, I agree. I think that's I think a good summation of the issue around certainty. Sort of changing gears slightly and going back to what Bharat had discussed on the regulatory front. There have been a slew of regulatory changes as well, which again, one would have hoped that they were going to enable deal making, and the intention perhaps was to enable deal making, but has inadvertently raised a lot of issues. I think one of the pet peeves that most acquirers have in India is the inability to do take private transactions. Yes. Delisting regulations being the primary cause of that. Now, the change in delisting regulations was meant to hopefully do away with that problem, but it doesn't seem to have had the desired effect. Do you have any thoughts?
Yeah, as I just mentioned a little while ago, if you see, SEBI did a wonderful job. It came out with a paper, a very comprehensive paper on what happened with the previous delisting regulations. It gave statistics which clearly indicated that the delisting was not working out. There is reverse book building was being controlled by a mafia, the minority shareholders, and the prices which were thrown up were unacceptable to the promoters in control to delist the company. So we are all hoping, and internationally what are the best practices, everything was discussed. But finally when it came to the crunch of framing the regulations after inviting public comments, they still retained the reverse book building. Some changes have been made. One fundamental change which is made, which is in the right direction, is that now you can use the tender offer route to delist a company, which was not allowed under the earlier takeover code and delisting regulations. But still, even under the new regulations, and which incidentally were cleared by SEBI board almost 5-6 months ago, but yet not notified. I'm told they are getting notified on Monday. Will still not go in a long way. Still requires some further tweaking to make it effective. I tell you other host of issues. For example, I find in negotiating share purchase agreement, the maximum time I'm spending on a clause which I never used to spend a time on, withholding tax, particularly if there's a transaction between resident and non-resident. Because today nobody is sure whether the tax will be levied, it is a capital gain or as a business income. The kind of issues which have been thrown up, what rate you should deduct withholding tax and what should be the terms and conditions of tax indemnity. Third, Competition Act. For example, everybody knew that you need to do competition filing only when you signed a binding agreement. Then only that's what the law says. But in Tesco deal, which we did, the Competition Commission took a view that no, you do filing when you file an FIPB application. Now, this was the first case of FDI and multi-brand retail. We didn't know what conditions the Ministry of Commerce will impose while approving the proposal. If the conditions were very onerous, there is a very likelihood of the Tesco would not have come to India. So, despite that, a view was taken that you should have come to us when you filed an FIPB application. when we are not sure whether we'll get the approval. And they levied a penalty. So if you see number of instances, how to calculate turnover, what is dominance in the relevant marketplace, they are not coming out, Competition Commission of India is not coming out with the guidance notes. In Western countries, European Commission, Federal Trade Commission has come out with exhaustive guidance notes on horizontal mergers, vertical mergers. You are aware of it, you are coming from New York market. Everything is clear. Here, not a single guideline has come on how to determine dominance, what is the relevant product market, what are the criteria is going to be applied. So there are a whole host of issues. In fact, I don't know, but Delhi High Court is currently hearing a petition challenging the constitutional validity of the entire provisions relating to Competition Commission's power under Section 3 and 4 of the Competition Act. And there is a very likelihood that it may be held as unconstitutional. Just last week, Madras High Court has said that the entire intellectual property rights appellate tribunal is unconstitutional. So we are passing through a situation of a flux where some of the very existence of our regulatory bodies is currently under challenge before a Delhi High Court. And I tell you another example, one uncertainty which is hurting a lot of investors. You bring any new project, greenfield or brownfield, M&A transaction, some PIL is filed by some NGO or some public activist and stalling the whole process. And it goes in Delhi High Court. Two of our airline joint ventures are still being heard in Delhi High Court because somebody felt that it's, the press note 6 allowed only greenfield, FDI in greenfield and not in brownfield and all kinds of issues. Lack of clarity, inadequate drafting that leads to, and the foreigners don't like this, that one year, 2 years after the airlines have commenced their operations, still there is a hanging sword. Something is under challenge. Jet Etihad deal was also struck right up to Supreme Court. And courts are also entertaining such petitions. These are all matters of administrative law. Should be left to the executive how they interpret the press notes. But unfortunately, the judiciary in India is also getting into areas where it should not get involved. It has enough work on its table. We have how many million cases pending in various courts in India. So why are they adding the burden by entertaining this kind of PILs? But PILs in India is effectively VIL, vested interest litigation. So most of your business rivals will file that litigation. So these are some of the other issues which are causing more heartburns to a foreigner that we are not sure when we can close the deal. Now, for example, even the Insurance Act, which is amended yesterday, there is this entire concept of Indian owned and control. How is IRDA going to interpret what is Indian owned and control will determine 26 joint ventures which are currently in the insurance space, whether they would to undergo the modifications of those agreements, because most of the shareholders agreement will have affirmative voting rights. So whole host of issues will come up in deciding Indian owned and control. Press note 6 uses the word which is dealing with civil aviation, effective control. The effective control should be in Indian hands, but what is effective control is not defined. So it is left to the judiciary to define what is effective control. So I can go on and on, but all I'm trying to say is we need to travel a long distance to bring about a regulatory certainty. The government is moving in the right direction, but there is still a lot of distance to cover.